Good morning. President Trump signed the Epstein Files Transparency Act into law on November 19th, 2025, directing the Department of Justice to produce all documents, files, records, videos, and images related to the investigations and prosecutions of Jeffrey Epstein and Ghislaine Maxwell. I'm here today to talk about the department's compliance with its production obligations under the Act. Around, I think right now, and continuing throughout the day-to-day, as the indexing and uploading completes, we are producing responsive materials under the Act. We are also releasing today a letter we are transmitting to Congress and various internal protocols associated with our review. I want to take a moment to thank the professionals at the Department of Justice who met twice daily, sometimes more, for the last 75 days to get to where we are today. The leadership teams from the Office of the Attorney General, from the Deputy Attorney General's office, the Associate Attorney General's office, the Criminal Division, the National Security Division, the FBI, the Southern District of Florida, the Southern District of New York, and the Northern District of New York all gave up many hours every single day on top of their other, of course, full-time obligations to fulfill the President Trump's promise of transparency to the American people. I also want to thank the more than 500 lawyers and professionals across all those divisions that I just mentioned and others who worked long days, nights, weekends, Christmas, New Year's Eve, New Year's Day, nights, weekends, and holidays to complete this production. These highly trained reviewers spend their careers putting bad guys in jail and effectuating the mission of the department. And to a person, they work tirelessly to protect victims and comply with the Act since its passage. So thank you to all of them. Today, we are producing more than 3 million pages, including more than 2,000 videos and 180,000 images. In total, that means that the department produced approximately 3.5 million pages in compliance with the Act. Just a quick note about the videos and images. The 2,000 videos and 180,000 images are not all videos and images taken by Mr. Epstein or someone around him. They include large quantities of commercial pornography and images that were seized from Epstein's devices, but which he did not take or that someone around him did not take. Some of the videos, though, and some of the images do appear to be taken by Mr. Epstein or by others around him. Now, I want to talk for a few minutes about the department's document identification and review protocols. It consisted of multiple layers of review and quality control designed to ensure compliance under the Act and protect victims. On top of the review protocols that the department had in place, the United States Attorney's Office for the Southern District of New York employed an additional review protocol to ensure compliance with a court order requiring United States Attorney Jay Clayton to certify that with respect to certain materials, a large quantity of the materials, a rigorous process was undertaken to protect victims against any clearly unwarranted invasion of their personal privacy. The department's collection effort resulted in more than 6 million pages being identified as potentially responsive, including department and FBI emails, interview summaries, images, videos, and various other materials collected and generated during the various investigations and prosecutions that the Act covered. We erred on the side of over-collection of materials from various sources to best ensure maximum transparency and compliance, which necessarily means that the number of responsive pages is significantly smaller than the total number of pages initially collected. That's why I mentioned a moment ago, we're releasing more than 3 million pages today and not the 6 million pages that we collected. I want to address what we didn't produce. The categories of documents withheld include those permitted under the Act to be withheld, files that contain personally identifiable information of victims or victims' personal and medical files, and similar files, the disclosure of which would constitute a clearly unwarranted invasion of personal privacy. Any depiction of CSAM or child pornography was obviously excluded. Anything that would jeopardize an active federal investigation. And finally, anything that depicts or contain images of death, physical abuse, or injury, also not produced. Although the Act allows for withholding for items necessary to keep secret in the interest of national security or foreign policy, no files are being withheld or redacted on that basis. Further, as we previously stated in our December 19th letter of last year, the Department withheld or redacted files covered by various privileges, as we always do, including deliberative process privilege, work product privilege, and attorney-client privilege. As you all know, under the Act, the Department must subsequently submit to the House and Senate committees on the judiciary a report listing all categories of records released and withheld, a summary of redactions made, including the legal basis for such redactions, and a list of all government officials and politically exposed persons named or referenced in the Act. We will do so in due course as required under the Act. I want to talk for just a moment about the redactions that will be obvious to anyone who reviews the materials that we just produced today. In addition to the documentary redactions, which includes personal identifying information, victim information, and other privileges, there is extensive redactions to images and videos. To protect victims, we redacted every woman depicted in any image or video, with the exception of Ms. Maxwell. We did not redact images of any men, unless it was impossible to redact the woman without also redacting the man. To this end, though, and to ensure transparency, if any member of Congress wishes to review any portions of the responsive production in any unredacted form, they're welcome to make arrangements with the department to do so, and we're happy to do that. I want to talk for a minute about something that is important. Every single day of the year, the Department of Justice investigates and prosecutes those who abuse and traffic young women and children. Just last year, the FBI located over 2,700 victims of child exploitation. The Department of Justice found and terminated 3.8 million dark web pedophile accounts. In August, we charged 11 defendants for extensive sex trafficking in Los Angeles of illegal immigrants and underage women. Last month, we charged 5 men who were engaged in a sadistic sextortion network of deranged young men abusing women. Over the past several months, last summer and into the fall, we executed Operation Restore Justice, rescuing 205 child victims and arresting 293 offenders. I point this out because I take umbrage at the suggestion, which is totally false, that the Attorney General or this department does not take child exploitation or sex trafficking seriously, or that we somehow do not want to protect victims. We do. There are some select members of Congress and some in the public eye, including those most critical of our efforts at full transparency under the Act, who remain silent as to all the work that we have done and continue to do every day in this space, while quickly pointing a finger at the Attorney General or this department because we were careful in our review of millions of pages of documents over the past 2 months. The Attorney General, the Director of the FBI, and our partners throughout this administration work hard every single day to protect the most vulnerable among us. With the production of this magnitude, mistakes are inevitable. We, of course, want to immediately correct any redaction errors that our team may have made, and so the department has established an email inbox for victims to reach us directly to correct redactions and any concerns when appropriate. That's been in existence since December, and we've been doing that since then. Finally, a very small portion of the documents collected pursuant to the Act include materials that a law firm produced to the SDNY in 2019 pursuant to a grand jury subpoena. This was during the criminal investigation of Ms. Maxwell. We determined it would be prudent to seek an order from the court in the Southern District of New York seeking production of these materials subject to the protective order in that civil lawsuit. To that end, the department has filed that motion with the appropriate judge in the SDNY, and if that motion is granted, we'll release those materials with appropriate redactions immediately. Today's release marks the end of a very comprehensive document identification and review process to ensure transparency to the American people and compliance with the Act. The department has engaged in an unprecedented and extensive effort to do so. After submitting the final report to Congress as required under the Act and publishing the written justifications for redactions in the Federal Register, the department's obligations under the Act will be completed. I'm happy to take any questions anybody has about that.
Todd, I'd like to ask you about this, and I have